Legal loopholes, credit repair tactics exposed. Chapter 5. The dispute process. The dispute process is a process that credit repair clinics use to line their pockets with your hard-earned money. This is why many credit repair companies advertise that they have a team of lawyers on staff and so on. They want the whole credit repair process to seem much more complicated than it really is. After all, this is how they get their money. Some credit repair companies charge up to several $1,000s for disputing items on your credit report. These companies take advantage of a clause in the Fair Credit Reporting Act that allows consumers to dispute the accuracy of their credit reports. The dispute process is fairly simple, and I will show you how to effectively do it yourself. Keep in mind that I used to have a credit repair business, so I will give you the inside scoop. Any consumer can legally dispute inaccurate, incomplete, or unverifiable information contained in their report. Disputing is a fairly quick and easy way to remove injurious items from your credit report and can be done by mail, telephone, or online. Online. Okay. So in a matter of a few keystrokes and the click of a mouse, you can dispute items on your credit report. The Consumer Data Industry Association, CDIA, recently provided a grant to many qualified professors to do a full study of thousands of consumers involving their three major credit bureaus: Experian, Equifax, and TransUnion. The key findings included that 95% of the thousands of participants in the study that disputed items on their credit reports were satisfied with the results. In addition, the Federal Trade Commission, in a report to the Congress on the Fair Credit Reporting Act dispute process, stated that one large credit bureau noted 95% of those who disputed an item is satisfied with the outcome. Under the FCRA, you have the right to dispute inaccurate information. Inaccurate information is subject but not limited to the following. Not mine. The account status or payment history. Credit limit or high balance incorrect. Duplicate collections. The date the account was opened. Inaccurate information. Illegally re-aged accounts more than 7 years old. Not liable for account, i.e. spouse. Accounts listed incorrectly. Account was closed by you and not the creditor grantor. Shows a repossession when it was voluntarily surrendered. Paid the original creditor before account was transferred. Identity theft or fraud. Account was included in bankruptcy. Account belongs to someone else with the same name. Company stated that they would delete it. Did not give permissible purpose for inquiries. Unauthorized users. Negative accounts from divorce. So those all considered not mine, as far as like, that wasn't me on your credit report. So you can dispute that. Next is the provision in the law that allows the provision is as follows. Section 611, procedure in case of disputed accuracy. A reinvestigation of disputed information. That was A. 1. Reinvestigation required. And it's one of those laws again. So it's 611, procedure in case of disputed accuracy. Brackets 15 USC. Looks like a dollar sign. 1681I. Bracket. in general, subject to subsection F, if the completeness or accuracy of any information contained in the consumer's file at a consumer's reporting agency is disputed by the consumer and the consumer notifies the agency directly or indirectly through a reseller of such dispute, the agency shall free of charge conduct a reasonable reinvestigation to determine whether the disputed information is inaccurate and record the current status of the disputed information, or delete the item from the file in accordance with paragraph 5 before the end of the 30-day period beginning on the date on which the agency receives notice of the dispute from the consumer or reseller. That alone is confusing just reading it. I wonder if they make them like this purposely. How it works. When you dispute information, the credit bureau contacts the source, creditor or collection agency, that provided the information. That source in return has 30 days to respond to the credit bureau. However, if the source of the information cannot verify the information or fails to respond within 30 days by law, the account must be deleted. If the information comes back verified, you can request a reinvestigation. You can also request that the credit bureau give you a description of the procedure used to determine the accuracy and completeness of the information, as well as a bureau named, address, and telephone number of the provider of the information. Pursuant to the FCRA 611, the credit bureau must provide this information as stated, not later than 15 days after receiving a request from the consumer for that description. Getting started. Recent studies show that about 79% of credit reports contain errors, so you must begin by checking for errors. You can start by making sure that all the personal identification is correct. Scroll line by line, inspecting your report for inaccuracies. This would consist of your name, social security number, date of birth, phone number, employment history, present address, previous address, and also variations of this information. The next step you want to take is to look under the hard inquiries and verify that you have initiated all the inquiries listed on your report. By verifying the inquiries, you can immediately know if you have been the victim of fraud and further check your report to see if there is any corresponding account to correspond with the fraudulent inquiry. I would proceed to verify that all the accounts, public records, liens, collections, etc. are yours or mine. Then you should proceed to check the account information, look at the payment history, and verify that it is correct. For example, make sure that the creditor has not listed the account as 30, 60, or 90 days late when you actually haven't missed a payment. I would then begin to check my account balances and verify that they are correct. This includes high credit balances, credit limits, payment history, etc. The account status, pay status, will usually let you know the status of an account. Example, it might say paid as agreed. You can usually identify all the negative accounts because they will be listed under a section heading that states adverse accounts or potentially negative accounts. I would place those to close scrutiny on those accounts and look for any errors. Remember that you can dispute any item if it is inaccurate, not accurate, incorrect, untrue, incomplete, lacking some part or not complete, unverifiable, not yours, etc. See the previous list of potential disputes. For example, inaccuracy would be if the account balance was $750.50, but it should be $750.25. Or the account was closed on December 5th, 2012, but it reports that it was closed on December 19th, 2012. That is technically inaccurate. People find many creative, truthful reasons to dispute an item. Many people dispute for various reasons, unaware that creditors and collection agencies keep records of previous disputes. The credit industry standard software, eOscar, has the capability of documenting and archiving all your previous disputes. Some people will dispute an account balance, and then if the account was not deleted, they would turn around and then say the account was not theirs. Why would you dispute the account balance on an account that's not yours? When disputing, it is best to be vague. Stating simply that the account is inaccurate, incomplete, or unverifiable is good enough. This is especially true if you don't have any documentation or legal ground to stand on. I'll read that again. When disputing, it is best to be vague. Stating simply that the account is inaccurate, incomplete, or unverifiable is good enough. This is especially true if you don't have any documentation or legal ground to stand on. Disputing. Once you have identified the potential negative items, you are ready to dispute. Note, each major credit bureau, Experian, Equifax, TransUnion, is its own entity, and you must dispute items at each bureau individually. You can't dispute an item on TransUnion and expect it to be deleted from your Equifax report, but rather you must complete the disputing process with each individual bureau. Therefore, every time you dispute an item, you are going to have to write 3 individual letters or contact the 3 individual bureaus. Many credit repair companies use standard forms and computer-generated dispute letters to dispute. The credit bureaus as well are well aware of this and aren't particularly fond of credit repair companies in the first place. They deal with credit repair companies on a constant basis and are aware of their tactics and schemes. The Federal Trade Commission has also brought legal action against many credit repair clinics. You don't want to be misidentified as a credit repair company. That's why I suggest writing your disputes by hand. Do not use any of the standard computer-generated forms that can be purchased online. Simply write the letters yourself. This seems to make the process more effective and adds the personal human touch to your writing. Don't worry about misspelled words or bad handwriting. As long as your letter is legible, that's good enough. Try your very best to appeal to their sympathy emotions. Example, I am very distraught over the misinformation and this time-consuming process that it is taking to fix this injustice. It's really stressing me out. Please assist me with the unfortunate situation. You don't initially have to quote a bunch of laws when dealing with the credit bureaus. They very well know the laws that they are bound by. Many times, you get better results by simply being nice and courteous. Some credit repair companies' standard form letters state, I demand per FCRA 611 bracket 15 USC 1681I bracket, you delete this inaccurate information or else. Dealing with debt collectors, it may be another story. If after you have initially tried to be nice and it isn't getting you anywhere, then I would suggest standing your ground and sending demanding legal letters, with each letter intensifying as the unresolved process goes on. See, I didn't know nice and courteous would go a long way with them. So I guess it's good to be nice and courteous at first, but yeah, if you're not getting anywhere, then go ahead and start demanding. Once you have located your potentially negative account and account number, judgment, docket number, public record, or inquiry, you are now ready to start disputing. Simply address the heading of your letter with all your personal information, name, social security, date of birth, and address address the letter to the credit bureau you are writing, Equifax, Experian, or TransUnion. Your name, social security number, date of birth, address, number, if known. And there's the rest of it for the letter. Your individual circumstances, account number, ABC Collection Services, which is name of the lender, public record docket number, judgment eviction. I guess that's all your your documentation, your backup. Remember, when closing your letters, be extremely nice, courteous, and thankful. Example: thank you very much for your assistance and for helping me with this unfortunate, time-consuming process. Please send me a corrected report. It is also important to note not to dispute more than 3 items at one time. Wait until you get your investigation result back before you dispute more. So I showed you the beginning and the end of that letter. This is the bulk of it. So this is the middle. You want your name and address of credit bureau you are writing, the date, and then writing the body of the letter is fairly simple, and you would state something to the following. Dear Sir or Madam, please note that after recently reviewing my credit report, I noticed that it contains some inaccurate, damaging information. You can state why the account is inaccurate, incomplete, unverifiable, etc. if you have a concrete argument. If not, you do not have to give the specifics. Just say, please investigate and delete the following accounts: public records inquiries, because they are incomplete, not mine, duplicates, inaccurate, whatever they may fit. More items. I will provide sample dispute letters. You don't have to use the exact wording, but you can tailor the letters in your handwriting to fit your individual circumstances or situations. In addition, when closing your letter, be sure to include carbon copy. By including this and sending copies of your letters to the agencies, Federal Trade Commission Attorney General, overseeing the major credit bureaus, they seem to take special care and handling in regard to your dispute. Note that some people include this carbon copy but don't send the carbon copies to the other parties and merely use it as a form for their letters. Alright, disputing online or by phone. So personally, I would probably still not do it over the phone or online. I'd still write letters, but this may be something different as far as the other books that I've read about doing online disputing. So before disputing online, it is important that you have a copy of your major credit reports. Each individual credit reporting agency has its own report confirmation or file number. You may need these numbers to initiate a dispute online or over the phone. Once you have obtained copies of your credit reports, you are now able to call the credit bureaus with the telephone numbers listed on the reports as well as the confirmation numbers and begin to dispute the process. You can use the automated prompt process or talk to a representative. Simply notify the representative that you would like to dispute the account, name and number, for whatever your reason may be. It is a fairly simple process. Within about 30 days, you should be notified by mail, or you can call and check the status of the dispute with the representative or by the automated system. Disputing online is just as simple. Simply obtain your credit reports, log on to the credit bureau's website, Equifax.com, Experian.com, or TransUnion.com, and click the Initiate a Dispute icon, Online Dispute, or Dispute links. The site may ask you for your report numbers from the credit bureaus. Enter these numbers in with your personal identifying information and you are ready to dispute. The site will give you a list of the reasons why you want to dispute the account. Example, not mine, is it fraud, etc. Simply check the box reason that best describes the dispute and the dispute is complete. You can also check the status of the dispute online or by phone. So he didn't even say anything about it giving up your rights if you do it online versus sending in by mail. So I guess you can do it online. I eat my words. Tactics and strategies for disputing effectively. Tactics involve the manipulation of forces in battle and maneuvering them to accomplish an expected end or goal, while strategy is the science or art of employing all the elements and movements, including the careful, precise planning. Listed below are some of the tactics, strategies, and legal loopholes that can be used to regain conquered ground. They are as follows. When disputing, start with closed accounts. If the account is open, there is a good chance that the creditor will verify it. When disputing, start with the oldest closed account first. Many times, older accounts have been sold or transferred multiple times, and the current debt collector doesn't have verification of the debt. Additionally, the Equal Credit Opportunity Act only requires creditors to maintain written documentation for 25 months. See Chapter 15 of this book. We'll get to that. Handwrite your disputes to the credit bureaus. Do not use standard computer-generated dispute letters. These handwritten letters only apply to the credit bureaus and not collection agencies. When dealing with collection agencies, draft legal-looking documents on word processor. Paid collections and paid closed negative accounts are pretty easy to dispute and have been deleted from your credit reports. Debt collectors usually will not verify closed paid collection accounts because they have already received their money. Remember, even if an account is listed on your credit report as a paid collection or paid after charge-off, it is still negatively impacting your score. Look for duplicate accounts. Many times the original creditor will report the account as derogatory and sell it to a collection agency, who will also list it as derogatory. Many times the same single negative account can be on your report as many as 2 or 3 times. This is illegal. This is illegal. Simply dispute the accounts with the credit bureaus and inform them that they are duplicate accounts. Scrutinize your credit report for outdated accounts. Outdated accounts are those accounts that are past the statute of limitations, 7 years. The 7-year period now starts 180 days after the account first became delinquent. However, it is used to be from the date of the last activity. Congress has changed this so that debt collectors can't continue to re-age old accounts. If your credit report contains several previous addresses, request that they be deleted, all but 2 or 3 of the previous addresses. What? If your credit report contains several previous addresses, request that they delete all but 2 or 3 of the previous addresses. Okay, got it. By having pages of your previous addresses on your report, many lenders perceive that you are unstable. Simply list the addresses and request that they delete them. Also, check your credit reports for different names and social security numbers, variations. If you notice that there are multiple names or social security number variations, request that they delete the inaccuracies. Never dispute more than 3 items at one time. Credit bureaus may flag your dispute as frivolous. Simply dispute approximately 3 items every time you dispute until you are satisfied with the result. If you close the account, it should state closed by the consumer, not credit grantor. Consistency is the key. If at first you don't succeed, try and try again. If an account comes back verified, wait about 30 days and dispute the account again and again until it is deleted. Sooner or later, someone will fail to verify the account. If the credit bureau sends you a letter saying the dispute is frivolous and they already investigated it, find a new factor or reason to dispute that account. See figure 1. We'll get to that. A new factor could be any new information that you obtained from the original creditor or debt collector. Call or write the credit bureau and notify them that since the time of the last dispute, there has been a significant change that warrants a new dispute. Example, they have agreed on a settlement, they have agreed to correct the error, they are updating their file, you have since disputed the account with the original creditor, etc. Carefully strategize your attack and send a barrage of dispute letters attacking the inaccurate, incomplete, or unverifiable information contained in your report. Remember, if you fail to plan, you plan to fail. Keep accurate documentation of all your disputes. Organize a file consisting of all your disputes and documentation, past and present. This will prevent you from making inconsistent statements, as well as having documented proof, certified mail receipts, dates, etc. to use at a later date or in legal proceedings. These are the most common disputes ranked in order. Number 1, it's not mine. 2, dispute payment history. 3, claims that they closed the account, which is the consumer. 4, claims that the account is closed. 5, disputes the balance. 6, inaccurate information. 7, credit limit incorrect. Account belongs to someone with the same name, which is 8, and then 9 is identity theft. If the credit bureau cannot verify the information, they must respond according to the FCRA, Section 611, which states the following. A. In general, if after an investigation under paragraph 1 of any information disputed by a consumer, an item of the dispute is found to be inaccurate or incomplete or cannot be verified, the consumer reporting agency shall promptly delete the item of information from the file of the consumer or modify that item of information as appropriate based on the result of the investigation. 2. Promptly notify the furnisher of the information that the information has been deleted from the file of the consumer. Remember that the credit bureau has 30 days to respond to your dispute. The FCRA states before the end of the 30-day period, beginning on the date on which the agency received the notice of the dispute from the consumer or reseller. If you are unable to get results, write the Attorney General and Federal Trade Commission. Addresses are in the appendix. Explain to them that the nature of your dispute and what laws the credit bureau or collection agency has violated. It is important to write to the Attorney General in the state where the credit bureau or collection agency is located. Once you get a response from them, which is the Attorney General, Federal Trade Commission, You can include a copy with your next dispute. We are living in a sue-happy society. If after several disputes you are unable to successfully remove the inaccurate item, you may want to consider retaining an attorney and suing the credit bureau or collection agency. Your attorney can obtain an injunction from the court to stop the agency from reporting the inaccurate information. In addition, you may be able to receive compensation, damages, and attorney fees, especially if you were denied credit because of them reporting the inaccurate information. Visit LegalShield.com. It is very important to keep carbon copies, certified mail receipts, verification of all your credit correspondence with the credit bureaus, just in case you have to take them to court. Contact information for initiating disputes. Got TransUnion online. You can go to https://dispute.transunion.com or call them at 800-916-8800. Monday to Friday, hours are 8 a.m. to 11 p.m. Eastern Standard Time. Closed on major U.S. holidays. Then you have Equifax. Phone number 800-685-1111. Address P.O. Box 740256, Atlanta, Georgia 30374. Experian. Phone number is 888-397-3742. And online you just go to www.experian.com. I used to be in the credit repair business, and I know from firsthand experience that I never wanted my clients to know how simple the dispute process was. This is why many credit repair companies advertise that they have a team of lawyers. Did I read this? Lawyers on staff, etc. They want the whole credit repair process to seem much more complicated than it really is. After all, this is how they get their money. Additionally, the law prevents credit repair companies from guaranteeing results. So here's figure 1. Sample dispute reinvestigation. You want to put your name and address, social security number, your date of birth, the name and address of the credit bureau, reinvestigation pursuant to FCRA. Here it is continued, the second page. Date, Dear Sir or Madam, please note pursuant to the FCRA, Section 611, I am requesting a reinvestigation of account, name and number, inquiry date, or judgment number. Since I have last disputed this account, I have taken the following actions. List the new actions you have taken. Example, contacted the original creditor, talked to collection agency, etc. Additionally, I had notified your state Attorney General and the Federal Trade Commission in regard to this matter. Please reinvestigate this account as it is inaccurate and it is damaging to my credit. Please provide me with the description of the procedure